So, welcome back to Intro to Criminal Justice. My name is Professor Fields, Professor for the People, and I'm really excited to talk about Chapter 3, which is Justice in the Law. Now, this is the last chapter before we start to transition into our more specialized topics within the criminal justice system. If you haven't been tuning in, just to give you a recap, we have three primary components of the criminal justice system. First one is law enforcement, the second one are the courts, and the third one are corrections. But this is our last chapter. While we are going to talk about justice in the law, and this does coincide with the courts, we're going to just give you a little bit of an overview of what the law is, again, from an introductory perspective. So let's jump right in. So it's very important to understand the development and use of law. It is a very challenging endeavor, but we do have a very rich history of laws right here in the United States. In fact, there's this concept of equal justice under the law. And this phrase is inscribed on the front of the United States Supreme Court in Washington, D.C. But is justice truly equal? We have to ponder this question because we know that there are high-profile cases, one of which I just mentioned a few lectures ago, that are going on right in our country. We also know that sometimes crimes happen in this country where there is no justice. People aren't brought to justice, or people feel that justice was not served. But when we look at the law, laws do change for a number of reasons. They change due to our society, what we see as acceptable, what is viewed as acceptable and unacceptable. They change due to cultural shifts. Maybe we are not as tolerant of certain laws in our culture, and even technology. Technology is constantly changing and shifting. But one of the things I want to say is that please keep in mind that laws that we have, laws that are in action, sometimes defy logic, fairness, and compassion. In other words, there's a great saying: we may not agree with the law, but we have to respect and follow the law. And that's a little bit what we'll talk about over the course of this lecture. So, bonus question: what was the first recorded murder? Right here in our history is in the Bible. You see, the Bible, this holy book, talks about the first recorded murder in history, and that first recorded murder was Cain slaying Abel. Abel rejected, or God rejected Cain's sacrifice. He loved Abel's sacrifice, and so Cain slew his brother. He was marked. And God even said in this book, in the Bible, that if any man were to cause any harm to Cain, God would slay them as well. So when we look at early history of the law, we see that there are codes of conduct which go all the way back in our history. For example, we have the Code of Hammurabi. Many of you may have heard of it. It's the eye for an eye doctrine. Eye for an eye, tooth for a tooth. If you knock my eye out, I knock your eye out. If you knock out my tooth, I knock out your tooth. It's focused on revenge and retaliation. Then we have the Mosaic Code of the Israelites. Again, coming back to the Bible. And if we go to the book of Exodus, right here in the book of Exodus, we have Moses who gets the Ten Commandments from God on Mount Sinai. It's called the law, and people have followed the law. But it's just that, the law. And then we also have the Roman 12 tables. This is a legislation that stood at the foundation of Roman law. They were laws inscribed on 12 bronze tablets, and they were created in ancient Rome around 451 BC. So we have early codes of conduct. We have early forms of law that have been introduced in our society. And whether, you follow religion or you don't follow religion, these are recorded in our history. Now, one thing to understand when looking at the law is that there are barbaric punishments, and there were certainly strange trials in early civilization. For example, you might have this thing called the trial by ordeal, this primitive trial in which God was expected to protect the innocent. So the belief, folks, was that if you were innocent, God would protect you. Didn't matter what this man did or this man did. If they were to go ahead and force you into whatever the trial may be, generally speaking, God would protect you, right? There were also extreme forms of cruel and unusual punishment. Now, we'll talk about cruel and unusual punishment when we get to corrections. There are things such as the gossip's bridle and the scold, stocks and pillory. I mean, there's a lot of different, brutal ancient forms of punishment, but we will save that for corrections. However, there was a period in our American history where there would be just unusual, unsanctioned trials that would occur based on hysteria perpetuated by people. And if you know what it is, you may know, but if not, perhaps this little hat, this little witch's hat might clue you in. You guessed it, the Salem witch trials. The Salem witch trials was a period of mass hysteria that occurred right here in our country, where in Salem, Massachusetts, you had women who were talking about how people were communing with the devil. They were practicing witchcraft. You had individuals, women that would be thrown at bottom of the lake with heavy rocks and heavy heavy objects tied to them. And if they drowned and died, well, then they weren't a witch. Because if they were truly a witch, they likely would have been able to get out of those devices. So just very much hysterical period of time, but that's how the law was. You're a witch because somebody gnashed around and shook around, so that person was a witch. Or this person had no children and was maybe talking in the middle of the night out loud, and they were a witch. It was a very much notable period of mass hysteria. So yes, as you can see, I'm very much a prop person, and I try to entertain you all with some different props each lecture. But this age of enlightenment brought new ways of thinking and reforms to this barbaric legal system. And one of the new ways of thinking was led by a man named Cesare Beccaria. Now, Cesare Beccaria, he became famous for this persistence in transforming the legal system despite attacks for legal experts in the religious elite. Now, Beccaria had a number of notable facts. One of the ones that really stands out is that he believed in free will, logic, and rationality, and how they were central in decisions to commit crime. This whole notion of free will ties right directly to a theory called rational choice theory. Again, I'm not going to get into it, but for those of you who may take criminal theories or may go on to criminal justice, certainly if you take me for criminal theories, or if you look at any of my lectures online as it relates to rational choice theory, you'll see exactly what I'm talking about. And this whole idea of free will being central in the decision making to commit crime is a core reason why individuals engage in criminality in the first place. They have a free will. They choose to do it. There's no other reason other than they made a self-conscious choice to do so. Now, there were two types of deterrence that existed. The first is the specific deterrence. This is directed towards an individual offender to stop bad behavior. Think about how something is specific to you. You have specific protocols that you follow, or you may have a specific routine on your day-to-day life. Maybe you wake up in the morning, you brush your teeth, you take your shower, you eat your breakfast, whatever the case may be. You have something specific to you. On the other hand, there is the general deterrence, and the general deterrence is the belief that there are negative consequences of being caught, like the perception of negative consequences of being caught, and the threat of punishment will affect all members of society and keep all members of society from engaging in crime. So specific is, hey, this person over here is a criminal. We have to make sure that they know straight up, you have had 2, 3, 4 strikes. Next time you commit a crime, you're going to have heavy incapacitation, heavy consequences. But on the other hand, with the general deterrence, there's the belief that, hey, we can go ahead and let the whole public know that if you do this bad behavior, everyone is going to be punished. Like, it's not a mystery. So that's the two types, the specific deterrence and general deterrence. And again, these are commonly talked about in other courses, such as criminal theories or corrections, because they tie directly into penology, which is the study of punishment. But St. Augustine, he once said, punishment is justice for the unjust. I love this statement. Punishment is justice for the unjust. So when people who are unjust or want to commit certain crimes, they will have to get punishment, and that is justice because of their unjust actions. So Beccaria, he believed in the importance of the social contract. In other words, he said that citizens should be willing to sacrifice a minimum amount of liberty to prevent anarchy and chaos. Now, one of the things that Beccaria really focused on were those principles of punishment, how punishment should be certain, swift, and proportional. When looking at punishment, you know that if you commit a criminal offense or criminal act, you will be punished. There is a certain punishment you will have. It will be swift. In other words, it will happen. It might not happen within a few days, but generally speaking, once you're apprehended or caught, you will face it, and it should be proportional. In other words, it is directly tied to the offense that you have committed. So punishment faces and incurs three principles, right? Again, these are things that are commonly talked about in corrections, maybe not so much in intro because we're not trying to give you too much, but certainly in a correctional course. However, we do know that punishment absolutely should be based on the act and not the actor. You can't punish me, Professor Fields, because, well, I don't like Professor Fields, because I don't like that he is animated or that he uses props or whatever, because I don't like that guy, right? But a professor over here who is maybe a little bit more monotone or maybe a little bit more dry or a little bit more, reserved, well, I don't want to punish that person because they're doing things the way I want them to do, right? That's going after me because of a personal characteristic, right? We can't do that. We have to punish people based on the act. So if Tommy and Susie and Fred and Linda all commit the same crime, then Tommy and Susie and Fred and Linda all get the same type of punishment. It's based on the act and not the actors, okay? So there's some other principles that are featured by Beccaria. For example, punishment should be determined by the crime, it should be prompt and effective, and all people should be created and treated equally. We know that the principle of people being treated equally is always a challenge, not just in this country, but in the world in general. But generally speaking, Beccaria was well ahead of his time because he's saying that, look, we can't just punish people because we don't like that person because of how they look. We can't just punish that person because we don't like that person's not educated. We need to punish them based on the act, regardless of their education, their looks, their socioeconomic status, whatever. It is very, very, very controversial because we know in today's day and age, sometimes we do feel that justice is not equal. That's a great debate for a class and certainly amongst yourselves. But generally speaking, Beccaria felt that punishment should be doled out where people are treated equally. Now, another individual who was a key pivotal figure when it comes to the history of law was a man by the name of Jeremy Bentham. Now, Bentham, from 1748 to 1832, he stressed rationality in the legal system, and he opposed brutal methods of punishment. Once again, we'll talk about some of the brutal methods of punishment when we get to corrections, but he was a genius. You want to talk about a person that was ahead of his time? Reading Latin at the age of 4, studying law at Oxford University in London at the age of 12. I mean, pure genius. We sometimes get what are called prodigies in our society. For example, I just recently saw something today where a young girl who's, I want to say, 12 years old is graduating from college with a 3.8 GPA. Now, you're a college student or you're watching this lecture and you're just interested in criminal justice. Could you imagine at 12 years old, you're graduating from college already? Like, you've already graduated from high school. You're just waiting till you turn 18 so you can start either working in the real world or going to, grad school or med school or law school or whatever. But yeah, we get prodigies out there. And Jeremy Bentham was one. He was, again, studying law at the age of 12. But Bentham had some key, he had some key innovations. For example, he looked at the hedonistic calculus. People weigh the costs and benefits of their actions. And he looked at the Panopticon prison design. It's a blueprint for current incarceration facilities. A person can watch others in a prison setting without others who are incarcerated knowing that they're being watched. So essentially, he was well ahead of his time, and some of his innovations are even used or understood or studied even today. And by the way, when you look at him right here, that is his actual body. Yes. Jeremy Bentham, he donated his body to science and to a museum, and that is his body that has been properly curated and cared for. I do believe, if I'm not mistaken, I think a couple of times a year they have to do something with the face. But that is his actual preserved body in a museum. He did not want to be buried. He wanted to be on display in London in a museum. That is his body. Now, classical theorists, they focus on free will and rational choice. Again, it just goes back to what Beccaria talked about. Rational choice is commonly used where an individual will make the conscious decision that they will commit crimes based on their own choice. As a fact, here it is right there. Scholars argue that the decision to engage in crime is a rational choice in which the offender weighs the benefits versus the cost. This is rational choice theory. So again, while you may not have to know any theory, and we won't really go into any theories in this course, understand that rational choice theory will always be the baseline theory within criminology and criminal justice. An individual will weigh the benefits versus the cost, the pros against the cons to committing a crime. That's why I highlight this, because this is very important when understanding why people engage in crime. Now, let's look at the role and purpose of law. We know that the rule of law mandates the application of known legal principles in governmental decision-making and establishes the premise that every citizen should obey the law. I said it before, and I want to say it one more time just to emphasize it. You may not agree with the law. You may not like the law. In some instances, you may not even understand the law. But we are all bound by the same principle. We must follow and respect the law. Some people will argue, well, I don't have to respect the law, but you better follow that law. And the reason why I say it's important to respect the law, because when we talk about the courts in several chapters, especially judges command a level of respect. It is extremely important to understand and know that judges command a level of respect, and you will follow and obey the law, especially in their courtroom. So the World Justice Project identified 4 principles associated with the rule of law. Members of the government are accountable under the law. In other words, if you work for the government, you must follow the law. We know this is controversial, but we're not going to get into this. Then we know laws must be clear, publicized, stable, fair, and they must protect fundamental rights. Each one of us has a fundamental right under the law. Laws are enacted, administered, and enforced in a fair and efficient manner. And then lastly, access to justice is denied to no one. In other words, it doesn't matter if you are black, you are white, you are rich, you are poor, you are a foreigner, you are not a foreigner, whatever the case may be. If the law is called or the law is involved in your particular case, then you have access to justice, period. If you are wronged by a person, even if you are indigent or you are very poor or you don't come from the most prominent background in society, you still have access to justice. These principles are very, very important, and sometimes they are overlooked, but they should never be forgotten. All individuals have access to justice, and no one can be denied that access. So what about some of the goals of the law? When we look at the law, we understand, and it's tied directly to punishment, and that's why I keep coming back to punishment. Because when looking at punishment, there are some critical points or some critical lessons when looking at punishment. For example, we have retribution. We talked about this with the Code of Hammurabi earlier in just this lecture. It's the eye for an eye, tooth for a tooth doctrine. We also have restitution. It's when someone is repaid due to their loss. It's a part of punishment where the person may have to pay the individual that they injured or damaged. They may have to pay them a monetary sum to make them whole. And we have rehabilitation. I talked about this before, but rehabilitation is providing treatment to someone who is sick or treatment to an offender who is deemed sick. And then lastly, of course, we have incapacitation. That's where a person is isolated from the public. Oftentimes, incapacitation can be confused with incarceration. Those are two totally different things. We'll talk about incarceration, but incapacitation is just isolation of an offender from the public to protect the public because nothing's working. We can't rehabilitate them. We can't treat them. We can't keep them in the community. So we have to isolate them for the good of the public. So two sources of criminal law exist in our country. First, we have common law. Common law was developed in Great Britain. Remember, we were birthed out of Great Britain, the original 13 colonies. But it was developed in Great Britain, wasn't meant for common men, but for English noblemen. And many scholars argue that common law discriminated against minority groups because if you weren't noble, if you didn't come from royalty or have noble blood, then the law was not applicable to you. What we have, because we came out of Great Britain, we were birthed out of Great Britain as a nation, we have what's called constitutional law, and that's the basis of all U.S. laws. Constitutional laws establish fundamental rules and relationships between the judiciary, legislative, and executive branches at the state and federal level. So, what I want to pose to you before I go on is think about an example of the executive branch, think about an example of what the judicial branch is, and think about an example of what the legislative branch is. Are you ready? So the executive branch of our country is the president of the United States. Typically, it's the president and the vice president. They are called the executive branch. The legislative branch are Congress. Congress, they usually write the laws. They come up with laws, and they hope that the laws will be passed and signed by the executive branch. Right? We have the Senate and the House of Representatives. We have 50 senators, okay? Because we have 50 states, 2 senators per state. So, or we have 100 senators, my apologies. We have 2 senators per state. We have 50 states, so we have 100 total senators, right? But we have hundreds and hundreds of members of the House of Representatives because every district has a congressman or a congresswoman that represents them. So we do have hundreds and hundreds of members of the House of Representatives. But with the Senate, we only have 100 total senators because each state has 2 senators, and that's it. And then lastly, we have the judicial branch. And the judicial branch is the Supreme Court. And the Supreme Court will often hear challenges to the law, whether or not people they're challenging the law, or they're filing a lawsuit, or they believe that their legal rights have been infringed upon. Oftentimes it could be heard in the highest court in the land, which is the Supreme Court. And we will talk more about the Supreme Court when we get to this section on courts. But as you see right here, we have the White House, which houses the President of the United States. We have the Capitol building, which houses Congress. And then we have, of course, the Supreme Court, which houses the judicial branch of government, which is the Supreme Court. So criminal law is broken into two primary areas. First, we have procedural law, how people are treated in the system. Think about the Bill of Rights, the first 10 amendments to the U.S. Constitution. What are some of our amendment rights? Again, we're not going to go over that now. We're saving that for another lecture, so I will come back to it. But then we also have the substantive law, and that designates what conduct is considered criminal. For example, what's first-degree murder versus manslaughter versus second-degree murder, and then manslaughter can be voluntary and involuntary. But one of the things I want you to take away from when looking at substantive law is that the burden of proof is always beyond a reasonable doubt. This is very important in criminal cases. We will come back to this, but the burden of proof is beyond a reasonable doubt. So if you're new to criminal justice and you've never heard this term, or you're like, wait a minute, I've heard beyond a reasonable doubt, but I never understood it. Well, we'll get into that in short order, but beyond a reasonable doubt means that there is no doubt that the individual who is found guilty or not guilty did or did not do the crime that they are accused of doing. It's not preponderance of evidence, which is the 50+1 standard, and we will talk about that soon. So just keep this in mind. That's why I highlighted it. Beyond a reasonable doubt is the burden of proof. So when looking at laws, and again, we have our laws in our country, which we do or we don't, we may or may not fully understand, but we must respect and follow the law. One of the most controversial topics, and we covered this a couple of lectures ago, is marijuana. In fact, marijuana is a controversial topic because of its current status. It's prohibited by federal law. We know that federal law is the supreme law of the land. It doesn't matter what state you're from. You could be from New York, you can be in Alabama, you can be in Texas, you can be in Georgia, you can be in Washington, you can be in Minnesota. It doesn't matter. The federal law is the supreme law of the land. Yes, we have state laws that we must follow, but the federal law will always supersede state laws. And so marijuana is a very controversial topic because marijuana is prohibited by federal law. In fact, marijuana is still a Schedule I narcotic. There has been a push by the DEA to reclassify it as a Schedule III narcotic, but that has not fully transpired. So because marijuana is still treated in the same vein as heroin and fentanyl and cocaine, it's going to be controversial because many have argued that marijuana does not have the same effects as those harder drugs. And the question I want you to ponder is marijuana a gateway drug? Do people graduate from smoking marijuana, smoking THC, to harder drugs? That's a question that we would debate heavily in class, but it's a question I want you to ask yourself and potentially answer, or go look at videos and go down the rabbit hole, because some have argued that marijuana is a gateway drug. It will lead people to doing other drugs. Again, right or wrong, it's not my job to tell you, yes, it is a gateway drug or no. We all have our own opinions, but this is why the federal government, for now, has still said it is a Schedule I narcotic. In other words, if you are transporting marijuana from, let's say, Kentucky to Tennessee, two border states, you can face federal charges for transportation and distribution of a Schedule I narcotic, even if it was marijuana. So keep that in mind. Now, other types of criminal laws include statutes, ordinances. Statutes are the governing body of a state legislature. It's like every state has their own statute. When we think of ordinances, those are municipal rules, mostly confined to cities, towns, and even counties. One of the things when looking at the law, there's this whole notion of precedent. Precedent looks at establishing prior case decisions as binding. So if precedent in a major case says that if someone is accused of some very heinous crimes, the precedent that we establish is that that individual will go to prison for 10 years. Generally speaking, we can assume and suspect that the outcome will be that that person will go to prison for 10 years. That's the precedent that has been established. So that is very helpful. In fact, it's what gives us what's called landmark cases in some cases. Landmark cases being those cases which establish precedent. There's landmark cases that we'll cover in future chapters, but these cases, even if you're not a criminal justice scholar, should stand out to you and should be a case that you go, well, I heard that back when I was in school, or I remember what that was. So landmark cases are very, very, very important. Now, when looking at law, while we have criminal laws, we also have to take a moment to recognize that there are something called civil laws. Now, criminal laws deal with crimes that were committed, such as, robbery, burglary, battery, anything like that, where there's a punishment that is clearly defined for the commission of the criminal offense. On the other hand, we have civil laws, and civil laws, generally speaking, deal with disputes between individuals or organizations, and somebody's trying to be compensated for the harm that was caused. So let me give you an example. When we look at a civil law, we might think that somebody, maybe someone, damaged someone's property. Yes, damaging someone's property is criminal. However, it can also be civil because let's say the property that was damaged was at a person's place of employment, or we can look at the fact that, somebody may have stolen someone's yard tools. Well, again, generally speaking, that's still criminal, but you also may file a civil suit too, because you may argue that, hey, the yard tools that were taken were for my lawn business. I lost money because I couldn't complete the contracts that I've signed. And so because of that, I'm asking for a civil trial. Well, in a civil trial, there's the number one standard, which is the preponderance of evidence, which is part of the burden of proof. But then you may ask for compensatory damages, money awarded for loss of injury or suffering through unlawful conduct, or punitive damages. The punitive damages are money awarded as a punishment to the defendant. In other words, you want to punish them for their recklessness, malice, and deceit. So it's very possible you get two different rewards, so to speak, or two different payouts because you get compensatory damages and punitive damages. But understand the burden of proof in a civil case is preponderance of evidence. It's the 50+1 standard. Whereas in a criminal case, the burden of proof is beyond a reasonable doubt. So again, some definitions, I'm not going to really go through all of these. I think the two that I want to stand out and that you could potentially see, again, are when looking at the elements of crime, you have to understand there's three key elements, but there's two that stand out. The actus reus, which is Latin term meaning the guilty act, it's the physical act of the crime. And then the mens reus, it's a Latin term meaning the guilty mind. It's used in court to prove criminal intent. Proving intent can be a very challenging endeavor because, if somebody does something to someone, it's very easy to prove the guilty act. Yeah, they physically did the crime, but you're asking, what were you thinking in your mind? What was going through your head when you were committing that crime? You may say, well, I blacked out, or I don't know, or I didn't even think about it, And so it becomes a very difficult and challenging endeavor when trying to prove the guilty mind. But the guilty act is always easy. It's considered the smoking gun, right? That one is that is a very easy element that can be proven in a crime. Now, I did tell you that we would talk about the difference between a misdemeanor and a felony, right? And crimes are based on their seriousness. When we look at a misdemeanor, those are less serious crimes, usually punishable by a fine, maybe a forfeiture, may even be a short-term confinement in jail, right? Usually less than a year, or in some cases, a year and a day. When we look at felonies, though, these are more serious offenses, and they result in very severe punishment. So a felony will result in a punishment that can include prison time. It may not include jail or prison, but it could be a very lengthy probation sentence. And again, we'll talk about probation when we get to our section on corrections. But generally speaking, these two are very important. Even if you don't know much about the criminal justice system, please, please, please understand that crimes are only categorized in two categories: misdemeanors and felonies. That's it. There's nothing else. You either commit a misdemeanor or you commit a felony. Someone says, well, you committed a misdemeanor, it's still a crime. So don't say, oh, well, I just did a little misdemeanor, it's okay. No, it's still a crime. But recognize that the punishment is a lot less severe than if someone did or completed a felony. So just keep those in mind. So when I talked about how even if you don't agree with the law, even if you don't like the law, even if you don't really even want to respect the law, you will follow the law. One other notable saying is that ignorance of the law is no defense. In other words, you can't tell somebody, you can't tell the judge, you can't tell lawyers, I didn't know or I had no idea, so I should not be punished. That does not work. That does not work. Okay? Yes, in a trial, criminal defense attorneys will try to say, well, the person maybe didn't know as much, or I'm not trying to excuse this, Your Honor, but I want to present some mitigating factors on why they committed the crime. It's not going to work, okay? Can't say you didn't know. Can't act like you weren't aware. Even if a defense lawyer that you paid thousands and thousands of dollars to is trying to make the argument be that you didn't know, it's not going to work, okay? It's not going to work. So ignorance of the law is never a defense for wrongdoing. If you don't know, the courts are going to say it's on you, ma'am or sir, to know. We aren't going to accept that as an argument. We do not do that. So key terms that exist when looking at legal defenses. Some of these terms, I'm not going to really go over them. But what I want to do is I want to put them up there. So if you've ever heard these terms, if you're watching a television show or if you're ever sitting around and you're watching a podcast or something on social media, TikTok or any other avenue, and someone says, well, I had a great alibi. You might be like, well, what's an alibi? Oh, an alibi is somebody that can vouch saying that the person was with them and they could not have been in the location or place where they were allegedly seen committing the crime. They could not have been present at the crime scene because they were with this alibi. And by the way, you may hear people say, my alibi is a rock solid alibi. In other words, not only can they vouch that I was there, but other people can vouch. We saw, Jeffrey over here at this location. There's no possible way Jeffrey was 20, 30, 40 miles away where this murder was committed because he was here with us the whole time. So you might hear some of these terms. But some other legal defense terms, entrapment, law enforcement convincing someone through trickery or manipulation to commit a criminal act he or she would have not otherwise committed. Listen, one of the most notable forms of entrapment involved, you may have heard of this show. It's called To Catch a Predator. Sometimes they'll be like, well, you entrap me. No. They did not entrap the individual. They knew good and well that the person they were talking to, while they thought they were a minor, was not a minor, okay? So you cannot say law enforcement entrapped me and now my charges should be dropped because you're embarrassed that you're on national TV trying to solicit services from a minor. Wrong. It's not happening. But people will try to use that entrapment. It's not entrapment, okay? It's not entrapment. In this case, we're looking at if law enforcement tried to trick or manipulate someone to commit a criminal act that they would not have committed. Maybe if you have an undercover law enforcement officer that's like, hey man, come on, let's go do this. And you're like, nah, I'm not going to do this. And then they're like, oh, no, come on. I'll start doing it. And that law enforcement officer is leading the charge. And then the individual starts engaging in the crime. And then they say, you're under arrest. Well, first of all, you're going to be like, you were leading the charge, and that's not going to stand in court. It's really trying to manipulate the person into committing the criminal act. That's probably the best example of entrapment versus an example of people trying to say it's entrapment and it's not entrapment. Other legal defenses include self-defense. Self-defense is when a person acts to protect themselves or their loved ones from imminent physical danger, which could have resulted in the victim's death. So we all have the right to defend ourselves, especially if death is on the table. We absolutely have the right to defend ourselves. So self-defense is a common legal defense that you may hear in court or on TV shows or on social media. And then lastly are some of the insanity defense standards. Some of these insanity defense standards are those that have been commonly used. The Naughton standard, the right-wrong test, do you know right from wrong, etc. But the Naughton standard is one that is commonly referenced. For example, another one, the battered women syndrome. Sometimes people will say, well, if this woman is constantly battered and abused or battered and beaten, she should be excused from the actions of, taking out those abusers. And in some instances, it is proven that women do suffer from battered women syndrome. But in other instances, if she stood over him 5 times and pulled the trigger, that's not the same as he was beating her and she fought back and pulled the trigger 1 time to shoot him and get away. There are differences that exist, but these are still some insanity defense standards that are commonly used in court. If you take a law school class, you will dive into these in greater detail. And lastly, we got to look at the rights of victims. The rights of victims are important in looking at the rule of law because victims have to be treated very fairly. Okay, they should be treated with respect, and they also should be treated with dignity. Generally speaking, these the way victims are supposed to be treated are found in this thing called the Victims' Rights Amendment, the VRA. And within this VRA, there's a discussion on not only how victims should be treated, but there's also discussion on victims in terms of they have the right to be heard, they have the right to be noticed about a release, they have the right to be present at court hearings, they even have the right to restitution. Even though victims are often overlooked, they're not even a part of the roadmap on the criminal justice pathway, understand that victims have rights. It's just a question of, do we give victims rights and considerations? Do we make sure that victims are heard and that they're cared for? Because we oftentimes look at the accused and their relationship and their response within the criminal justice system. So, as we wrap up, as always, I want to give you one key nugget to take away from. Within this chapter, yes, the rule of law dates back centuries, okay? Centuries. In fact, thousands of years. We have the Bible, we have the Code of Hammurabi, we have the Mosaic Code, we also have common law and our constitutional laws, so to speak, what we have here in the United States. But one thing that I want you to take away from is that, number one, ignorance of the law is never an excuse. Number two, whether you agree with the law or you like the law, you should and you must respect and follow the law. But I also want you to understand that when someone breaks the law, they've either committed a misdemeanor or a felony. One or the other. There's no in between. There's no, well, no, I did something else. No. There is no something else. If you break the law, you either committed a misdemeanor or you committed a felony. And when you have broken the law, there is a punishment that will follow. You might not want the punishment. You might not like the punishment, but there generally is a punishment that will follow. So I want to thank you for tuning in to chapter 3. When we come back on our next chapter, one of the first things we're going to talk about is law enforcement. But we're going to talk about it from a historical context on what law enforcement was and how we have gotten to law enforcement on where it is today. So thank you for tuning in. Take care, and I'll see you next time.